So I want to talk from the perspective of a lawyer that has primarily gotten referrals from other lawyers for 30 years. And many of these referrals come from newer lawyers who couldn't resolve a case, who bring the case to me to either settle the case or try it or get more money. And I hear routinely these newer lawyers say, oh, that adjuster was an asshole. Oh, I taught that adjuster a lesson. They knew that I was somebody to reckon with. I got to build my reputation as a tough guy, etc. And then I'll get in the case and I'll meet the adjuster, or I'll meet the defense lawyer who comes in afterwards, who has access to the file. And not surprisingly, the converse, the opposite of what this newer lawyer thought they were conveying is what they actually conveyed. Don't pay this dumbass a dime. He's an ass. He's not teaching them a lesson. He's teaching them how they shouldn't pay him anything based on the way he behaves. And so I learned early on something that I teach and that I really recommend is that you, first of all, treat adjusters and defense lawyers with respect, but also understand that litigation and personal injury in general is an adversarial system, but it is a collaborative process with the other side, whether it's an insurance company adjuster or a defense lawyer in-house or outside counsel. But it starts with respect. Even if that person is not giving you the respect back, even if they're saying things that are ridiculous, there is no need to become emotional and go down to a level. You simply stop talking to them and move on to their boss, their supervisor. If it's pre-lit, you file and you get to a different adjuster. If it's an associate, maybe you go to the senior partner on the case. But what you don't do is treat people with disrespect. That's not just for insurance companies, adjusters, and lawyers. That's for everybody. And I have learned over the years that if you don't have something nice to say, do your damnedest to shut your mouth and don't say it. I have learned that 60 to 90 seconds of pause before I send off that scathing email or say that, that cutting, biting comeback means everything to give yourself some perspective and maybe not send it. So respect is number one. But two, you have to understand that as plaintiffs' lawyers, what we want for our clients and for us is money. The carriers, through insurance companies, through adjusters, through defense lawyers, have the money. But they are set up in a way of a system of checks and balances that they can't get authorization and authority for money without giving information to their bosses. And we, the plaintiffs' lawyers, have the information. So as I said, it's an adversarial system. We want money. They have to give us money. We have information. They have to get information. But if I can make this a collaborative process, not only will I get money, more money, I'll get it faster. And one of the really important things that I talk about that I've learned is that insurance adjusters and in particular in-house counsel do not get credit for paying you less money. They get credit for resolving as many cases as possible within their reserves. So if you can do activities, and I talk about this in other videos on my Instagram, YouTube, LinkedIn, TikTok, I have forums, I've written a book about it, The Trial Lawyer's Bible, that there are many things that you can do to set those reserves as high as possible and continuously have them reevaluate the reserves to get them higher. That once it's a reserve is set, then all you have to do is give them the information that they need to get a number that is acceptable to you as long as it's within reserves. And the faster and better and more cohesive and lucid and understandable the information you give to them, then the faster that they'll go get you money and settle the case. They want to settle the case. And so I have a whole checklist of 80 to 90% of every personal injury case on both sides needs the same kind of information. They need all the medical records. They need all the Howell bills. They need the police report. They need to prove that you're not Prop 213. They need the property damage photos and the property estimate. If there's pre-existing injuries, they need those records, right? They need to know what the plaintiff looks like, how old they are, how much they weigh, how do they ambulate, how do they present. So they need photos and videos of what the plaintiffs looks like. And they need form interrogatory answers just to get them answered. And if it's in litigation, they need a deposition, maybe they need a medical exam. So if you organize your practice, pre-lit and litigation, that those things you want to give to them right away because they need that. to check off the boxes to get you money, but also you need it to value your case. So it's a win-win. But if you treat people with respect, understand that their job is not conspiring to screw you, but that they have to follow certain procedures. And if there are these miserable people, probably has nothing to do with you. It has something to do with their own life, their own situation, and they're just projecting on you. Then you figure out how to get away from that person, get to someone else, and then repeat the process. This is the secret, not only to getting more money for your clients, but to getting it faster, to having happy clients who refer you work. Good Lord, we are on this earth one time. It is also a great way for you to live your life of their way and get out of your own way. Change your mindset to a grateful, bountiful mindset that I am here to work collaboratively because I am a good lawyer who knows what I'm doing with good clients that I represent and happily giving you the information with the expectation that you will use that information to get us a fair and reasonable result over and over and over again. It's good business, it's good representation, it's good living. Come on now.